Good morning. Welcome to the week 4 video lecture. Starting off again with the discussion of just mercy. A general run through this chapter is dealing with Brian going in to meet Walter's family, his wife, his daughter, sitting down and talking with them. He also then presents some other information about other mentally ill individuals who've been on death row or who have been treated unfairly. He details his frustration and his worry about how Walter's going to be treated and how much time or influence he's going to be able to have while he is working with Walter. So there's a lot of to kind of unpack here with just kind of the family's thoughts, what it's like to be a family member of someone who's accused of a crime, especially wrongfully convicted of a crime. So make sure you read carefully, ask any questions, or journal any questions to me that you have about Chapter 5 of Just Mercy. Now this week in our course pack, we are dealing with expectation of privacy in the Fourth Amendment. And so the first case here is Katz v. United States. This case is vitally important to understand the Fourth Amendment. In Katz, Katz went into a phone booth to call his bookie and place a bet on some sporting events with a Vegas bookie. That at the time is a federal crime to use technology to place an interstate bet. The FBI had wiretapped that phone booth, and Katz challenged his conviction based on that information, saying that the police officers should have gotten a warrant. The expectation should have been that they got a search warrant before they wiretapped him. And his argument is that if there's a reasonable expectation of privacy, a warrant needs to be the first thing that officers do. And so really important for us to understand the Fourth Amendment is that this case introduces to us this expectation of privacy. Now, as you can see right here, it is a reasonable expectation of privacy, not an unlimited expectation of privacy. And courts subsequently break this down into two parts. There is a subjective component, subjective expectation of privacy. Under the subjective component, you as a person need to take steps to keep your privacy private. You need to draw your curtains, you need to lock your cell phone, you need to shut the door in your office when you have a conversation. You yourself have a duty to say, this is private to me, and here are the steps that I took. I subjectively kept it private. I locked it in a drawer. I put a password on my phone. I shut the door. Then society also needs to determine that that expectation is reasonable. And here the Supreme Court finds that it is reasonable that Katz expected privacy. He went into a phone booth and he shut the door. Were parts of him visible? Could you see that he was having a conversation on the phone? Yes. But the content of that conversation he kept private. He went somewhere and shut the door. Therefore, the government is not entitled to use that information to convict him. So Katz was able to win. What they wiretapped crossed the line. Okay? This case is really important, so if you have any confusion, let me know. This case is still playing out, especially with the innovations of new technology. We might see some drone cases working their way through the courts about things like this. What is an expectation of privacy? The second case assigned to you this week is Riley v. California. This is from 2014. And the question for the Supreme Court is, can officers automatically search your cell phone if they arrest you? And Riley was arrested for speeding or something along those lines. and officer took his phone and flipped through and searched it. They found evidence of gang activity, or what they thought was gang activity. They then used that evidence to convict him and to get a warrant. Now, search incident to arrest almost always is a pat down of your body, of any space you can reach into. So the question is, should that be expanded to include your cell phone? And the why is, well, it's on you and it has a lot of information available to you. The why not is that it has a lot of personal information on there. Cell phones frequently have information about health conditions, insurance, banking, as well as photographs, which can be extremely damning. And so the Supreme Court determines that warrantless searches and seizures of a cell phone are unconstitutional. So an officer is not out of luck. They can apply for a warrant to search a cell phone if they believe that there's evidence of criminal activity there. The officer is going to have to establish an independent probable cause. Okay. Again, if you have any questions, the video I think here is really great, but let me know. I'm happy to answer questions. All right, our next case in this series of cases for this week is Kyllo v. United States. Here we have government agents from the Department of Interior parking on the street outside of Daniel Lee Kyllo's home in Oregon. And they used a thermal imaging device. And when they use the thermal imaging device of people on the street, Daniel Lee Kyllo is emitting a significantly higher amount of heat signatures, heat energy, than any other home on the street. Because he was running a grow operation from his home. So he's growing marijuana, he has the heat lamps, he's using a tremendous amount of heat. The information that they got from that thermal image was taken to get a warrant, where the federal agents then discovered over 100 marijuana plants in his home. Kyllo challenged his convictions under the Fourth Amendment, saying that this search violated his Fourth Amendment rights. And what he argued is that police officers used a thermal imaging device to look inside of his home where they could not have otherwise gone. They did not have enough information to independently get a warrant without that thermal imaging information. They could not have gone inside without his consent. And they still used technology to peer inside of his house to get enough information to get the warrant to later on prosecute and convict him. And that's a problem under the Fourth Amendment. Your Fourth Amendment rights are the absolute strongest when you are at your house. And officers need to have independent probable cause. So Daniel Lee Kyllo wins. They cannot use that thermal imaging information to get that warrant. Okay? And then the next case we're dealing with is California v. Greenwood. Billy Greenwood was suspected of dealing drugs from his house. The police didn't have anything beyond, they didn't have enough probable cause to get a warrant. They had hunch, but they didn't have probable cause, so specific and articulable facts and circumstances that a crime is being committed, or this person has committed a crime, or that there's evidence of a crime. They did not have enough to get a warrant. So they waited for him to take out his trash, and they went through the garbage. In the garbage, they uncovered evidence of drug use. They uncovered paraphernalia and other indicators of drug use. They then used that information to arrest Billy on felony charges. So lots of drugs, right? And here, the police officers win. Billy loses here. So these first three cases, we have our defendant winning. That they can't wiretap the phone booth. They can't use a thermal imaging device on your phone, and they don't have an inherent right to go through your cell phone. Here we have the defendant losing. So the difference here is the expectation of privacy. Once Billy took his trash to the curb and put it outside at the curb, he is not holding on to that subjective expectation of privacy any longer. And therefore, it is fine for the officers to go through his trash. Okay, so this is kind of how this expectation of privacy works. When that trash was inside his house, he is still holding on to that subjective expectation of privacy. And objectively, we agree, police can't go into your house to search without a warrant. But once he takes his garbage out, that subjective expectation of privacy disappears. It no longer exists. And so the police didn't do anything wrong. They can use the evidence they uncovered from the garbage to convict him of drug charges. Okay. Our last case for this week is the United States versus Jones case from 2012. Here we have police officers attach a GPS tracking device to the underside of the defendant's car for 28 days. They uncovered hundreds of pages of information based on where the vehicle was and how long it was sitting. And they then used that to get a warrant. Jones was convicted of drug trafficking, and he was given a life sentence for drug trafficking. So he was trafficking an insane amount of drugs. They did not have enough information to, they exceeded their scope of the warrant when they left this GPS on there for 28 days. So at the end of the warrant's requirements, they just didn't take it off because they didn't have enough information to keep moving. And so the question here is, did officers conduct a search when they attached that GPS device to his vehicle? The time they did it, his vehicle was parked in a public parking garage, public parking structure in Washington, D.C. And here we have the courts again saying that this is a physical intrusion on the defendant's property, and they violated his personal effects. Remember, the language of the Fourth Amendment talks about your papers, houses, effects. Okay, so this is his vehicle is a personal effect, and they did it with an attempt to obtain information. That attempt to obtain information is a problem under the Fourth Amendment because they need a warrant that lets them do it. So they had one, but they exceeded the scope in geography and length of time. So he was also going in and out of the jurisdiction into Maryland and Virginia. They didn't have search warrants for Jones in Maryland or Virginia. So this is a huge invasion of his privacy. Okay, and subjectively, we don't expect officers to attach tracking devices to our vehicle. Objectively, we as a society agree that if police are going to attach a tracking device for 28 days, they should have a warrant. So the government here loses this case. They cannot attach wireless devices. So as we're thinking about these cases that we read together today, they are all essentially dealing with privacy. What is your expectation of privacy? What is reasonable? What is not? Did the defendant subjectively try to keep their information private? Did the government cross a threshold? What is going on? So this series of cases are all dealing with what is private and how we keep it so. All right. So after you watch this, read through the materials. If you have questions, please let me know. I'll be happy to answer them. Hope you all have a great week.